My name's Kathryn Taylor. I am a partner with Milberg. Despite my southern accent, I actually live here in Amsterdam and love it. But I assist our international offices and serve as a liaison between those offices and our U.S. office. So it's been a lot of fun, and it's been really great watching Europe develop and seeing how the laws are changing. We've got a great panel up here, and instead of reading all of their bios, I would love for them to just introduce themselves. So, Katie, I'll pass it to you ladies first.
So I'm Kathryn DeBord. Many of you saw me yesterday. I'm VP of Product Strategy at Disco. My career has been a winding road. I started actually as a complex commercial litigator and became a litigation partner, litigated many complex disputes, including defense class actions, and loved class action work. I never took any of those class actions to trial, and like John, I'm very jealous of that, but I'm happy to be here today.
My name is Glenn Danis. I'm a partner at Clarkson Law Firm in Malibu, California. It's very tough to be working in such a terrible environment. And I started my career on the defense side doing antitrust, merger and acquisition, and securities litigation for a large defense firm in New York City. Then switched to the good side, doing plaintiff's work starting in 2009, class actions for the last almost 13 years in primarily the consumer and the wage and hour employment spaces. And within that, excuse me, I focus mainly on appeals. Although I also do work at the trial and district court level and increasingly in mass arbitration.
Hi, good morning. I'm Michael Armitage. I'm with Waters Kraus Paul. I'm also based in California in our Los Angeles office, but I handle cases pretty much all over the United States. I handle mass actions for plaintiffs for the most part, including EU citizens. And primarily I do that in the toxic torts products liability field, but I also do some work in commercial fraud cases.
Great. Thank you all so much, and thanks everybody for being here. So our topic is the role of the lawyer in a class action. Our goal is to really just give you some practical advice for all the litigations that I'm sure all of you are involved in. We'll kind of take this just through the life of the case. So we'll start with pre-suit, we'll go into litigation, and then we'll end with some appellate talk. So starting at the beginning, we all have cases now that involve lots of different claimants all in one case. So I'd like to maybe kick it to Mike and have you talk a little bit about just how you figure out if you're going to file as a class action or a mass action, opt-in, opt-out, and where you would file, how you make those jurisdictional decisions.
Sure. Well, as you noted, you may have a class action or a mass action, and nowadays perhaps even a hybrid of the two, such as something in the United States that's known as an issue class action or a networked mass action. And obviously it's your job as a lawyer to figure out which your client's case qualifies for and what's the best option if you have a choice. And you should note you may end up with both. I'm currently working on a large case with a number of members of my firm based in New York that is actually filed both as a class action and a mass action. It's an international financial fraud case. But obviously the most efficient and cost-effective way to litigate, especially for the court and the plaintiffs, is the class action. But to qualify for that remedy, you have to meet certain legal tests of the jurisdiction where you need or hope to file the case. I'm obviously going to use America as an example because that's what I'm familiar with, but I understand a number of European jurisdictions, including the Netherlands, have similar rules as far as qualification for a class action. In the United States, that issue is governed by Federal Rule 23, and there are obviously many state law corollaries to that rule if you're filing your class action under state law. But in the case of a mass tort, which is where I primarily practice, and by the way, mass torts can sometimes make up 25% of the caseload of a particular court's docket in the United States, so they're really a big part of the litigation landscape there. But in those cases, you're almost certainly not going to be able to meet the predominance requirement of Rule 23, which stated simply means that the common issues amongst all of the claimants must predominate over the individual ones. U.S. courts have rejected class action approach for mass torts in a number of cases, including several famous United States Supreme Court cases, including Amchem versus Windsor and Ortiz versus Fiberboard, which are both asbestos cases. So which likely leads or leaves the option of just going through the more convoluted route of a mass action, which, although more time-consuming, complicated, and expensive, is actually the way that my firm prefers to litigate those cases. But the most common reasons why U.S. courts have found that a mass action or a mass tort won't qualify as a class action due to failing the predominance requirement is that you cannot assume uniform proximate causation amongst plaintiffs. Obviously, the extent of injuries and damages suffered by the plaintiffs can vary widely. There can be, in toxic tort cases, there can be variations in the etiology and pathology of diseases, and individual plaintiffs may have had exposure to multiple different substances that can be associated with the disease or injury that they're claiming. Other reasons that might lead to rejection of a class action include things as novel or immature legal actions in mass actions, choice of law issues amongst or for claims that have arisen in multiple states or countries, and also difficulties in giving notice to potential class members who might not yet even know that they've been injured. A recent example in the U.S. of a mass action being denied class action status is or was PPA. Some of you may know PPA, I'll try and say that the actual drug name, phenylpropanolamine, was an ingredient in over-the-counter cough and cold remedies, and it was linked to strokes and hypertension since about 1979. It was finally removed from the remedies in November of 2000, and hundreds of lawsuits followed. These were all coordinated in a single federal MDL in the United States, since all of the cases were deemed rooted in the complex core questions concerning safety of PPA. But it still failed to qualify as a class action because, again, the plaintiffs failed to meet the predominance requirement. The court found that issues of causation and other affirmative defenses depended on facts peculiar to each plaintiff's case. So what followed in PPA was a heavily networked mass action that was primarily conducted in a single federal court MDL and also in some coordinated state proceedings around the country. And what was interesting in that scenario is that the plaintiffs' lawyers, defense counsel, and even some of the judges acted in a form of network in sharing evidence, information, rulings, things like that. One other possible alternative you might have if you're filing a case in the United States and you can't qualify as a normal class action is to try and qualify as or seek an issue class action under Federal Rule 23C4A. This device has grown somewhat more acceptable to U.S. courts in recent years, although it fairly has been criticized and rejected by others. But the process allows resolution and binding issue preclusion on an issue or issues common to all of the class members while excluding the individual issues of class members from the class action and leaving them to be decided separately later by individual courts. As to your last question, I think about where can you file this action, it's obviously a complicated issue and probably the subject of a whole other panel. But the answer, of course, depends somewhat intrinsically on the law of the forum where you try to file the case or you hope to file it. But I always tell parties that are particularly EU citizen parties that are anxious to file a case in the United States that there are certain gates or really more like barriers really that a litigant has to pass through to act or to get their case filed and heard in the United States. And those barriers or gates include getting personal jurisdiction over the defendants, the venue rules of your particular court, which tell you where you can file the case, surviving the inevitable forum nonconvenience challenge that you're going to get after you hopefully select the correct venue, and then finally deciding what law will apply to the dispute, particularly if it's one that could have occurred in many states or even transnationally.
Great, thank you so much. I know managing these cases is very difficult because we often have hundreds of thousands or tens of thousands of claimants, and so I think it's important as lawyers that we really take advantage of the tools that are available to us, especially from a technology perspective. So, Katie, would you maybe want to talk a little bit about just the role of lawyer and the technology tools that are available to us.
Yeah, and I'm curious, how many people have used a review tool that has AI in it in this room? Artificial intelligence. Yeah, so maybe about a third, if I can see through the lights. It's a little bit hazy up here. You know, so it's, as we all know, and obviously, as you just said, there's just massive reams of documents and information, and it's really important from the plaintiff side and the defendant side to get through that quickly. From the defense perspective, which I was, you know, you really need to know whether you have, you know, a business problem, a reputational problem at hand where you need to get rid of it and settle it quickly. You also need to get your class certification strategy in order really quickly. From the plaintiff side, you need to understand whether you have some problems with your certification, especially in the United States, you know, that you don't necessarily realize. And using technology, and I'm saying this both as a lawyer and a quasi-technician, I'm not really a technician, but is absolutely critical, and using the right technology is critical. And you know, if you think about what artificial intelligence is, really what it does is after you've reviewed a certain number of documents, like 300, it is able to start deciding what documents are relevant and what documents aren't. And think about a magnet on the top of a haystack, and it pulls the needles up and basically pushes all of the responsive documents that it has decided are responsive to the top. And this technology is not like, you know, like 1980s technology, right? And so it actually works. It's approved by the courts. And even if you're the lawyer, which I know there's a lot of lawyers out there who want to review all 20 million documents, right? You can use a technology to see what's responsive first and get your strategy in order first. And if you really have to review all 20 million documents, so be it. But at least you know what your case is. At least you know what your facts are, and you can start, you know, organizing yourself appropriately. And I am going to put in the pitch right here that if you want to see what I'm talking about, go to Disco's booth, and you can see this kind of technology. Thank you.
I think saying that we want to review 20 million documents
I
is maybe
know.
a stretch, but feeling the need to do so.
Feeling the lawyer urge.
That's right, understood. Yeah, well, you know, during these cases, maybe kind of the last pre-suit question we can talk about, and Glenn, I'll kick it to you. You know, a lot of times we find ourselves kind of wearing different hats and needing to represent different claimant groups, and so maybe you can touch a little bit on just how to manage those interests when you know, you have a lot of different ones competing.
Yeah, well, thanks so much. You know, when we have an idea or class, you know, we're sort of percolating in our heads at the very beginning of the case, the first thing we put on is sort of this investigator hat of really trying to look at, you know, this case as a business proposition, as a justice proposition, from the perspective of, you know, whether this is something that's important. And we look at, obviously we look at the facts, but we also look at things like competing cases. These days, whether there's an arbitration agreement involved, which is a huge part of litigation in the United States these days in the class action space, the defendant's viability, if there's actually a judgment, what available damages there are, penalties, whether they be statutory or civil penalties, and whether there's a fee-shifting provision. You know, taking that off and sort of putting on the hat of being a counselor to the class, especially in a case that involves really the lives and livelihood of the class members, like in an employment case, which I work on quite a bit, we might be on the phone with or communicating by email with a variety of class members, talking to them about their experiences, and really just being, in some cases, a sounding board, in other cases, really you know, collecting evidence that we're going to need for the case. And then, you know, we sort of will shift once the complaint is filed and sort of put on the fighter or the bulldog kind of hat, which is one that made a lot of sense to me and earliest in my career, which was, you know, we start fighting. In the United States, so much of this is about civil discovery and documents that even though there's case law going back 20, 30, 40 years saying that we're entitled to, there might be weeks, months, or even years of fighting over, and sometimes even multiple appeals. And this is something that's very specific to perhaps certain types of employment cases in the United States and in California, but often I'm also in the role of putting on the hat of law enforcer, because we're standing in for the state of California or for the government in helping it to enforce its labor and employment laws through private rights of action. Obviously, that's controversial and something that's not something I've heard a lot about in this symposium, but this is something in the United States that plays a very large role, especially in California, and something that went to the United States Supreme Court last year to be decided. I won't get into it too much because we're about to go down the sort of lifeline of the case, but we also do put on the hat, ultimately, of deal maker and partner with the defense and with the court, which is something that is a very, very different sort of about face from where we are as adversaries. And then ultimately, perhaps if we're dealing with objectors or interveners, we take the role of the defender of the appeal, of the settlement on appeal.
Fantastic, thank you. Then maybe we'll move on a little bit into the actual litigation of the case, and I know you've heard a lot of times in the cases here in the Netherlands specifically, we go to procedure first. And so, Katie, maybe you can talk a little bit about just, I know you've been on the defense side some, how you can use procedure and the tools that are available within the law in the procedure side to really push the interests of your client.
Yeah, and I think this is where one of the reasons why I always loved class action work is that it's really creative, and if you know the rules well, you know the law well, you really can be creative in how you prosecute it or defend it. And I think I break it down into about 3 or 4 parts, right? The first is just the pleading requirements. In the U.S., there's some stricter pleading requirements around articulating harm. You can't just plead, the risk of harm. You actually have to plead concrete harm, and so that's kind of your first knockout. As I look at it, is do the pleading standards match up? And I don't know if the law has really been developed that much here, but that's one place. And then the second is looking at how you, if you want to, how you keep as much disclosure as possible out of play. So do you want to bifurcate, for example, disclosure and discovery around certification from the merits of the case? There's kind of like 2 ways of looking at it, right? Because on the one hand, it may limit your discovery. On the other hand, I think there's a really strong argument that once you do the discovery on certification, you really do kind of have the merits, which is why most cases settle in the United States after certification. And so if you bifurcate as a defendant, you can't move for a dispositive ruling saying that you win the case based on the facts that have surfaced. So that's kind of the second thing that they'll look at for knockouts. And then the third thing is looking at formation issues, especially in consumer class actions. I did a lot of consumer class actions, and as Glenn mentioned, arbitration's a really big deal. So can you compel arbitration? That is just a major deal in the United States. I was actually part of all those lines of cases getting up to conception, the ruling upholding class action bans and arbitration clauses. And sorry, plaintiff's lawyers.
I mean, maybe just let everyone know what Concepcion is.
Yeah, so Concepcion is the Supreme Court decision that upheld basically that you can have an arbitration clause with a consumer with a class action waiver, meaning they waive their right to a class action claim if they enter into that agreement. And so, if you can prove the consumer formed an agreement with you, the agreement had an arbitration clause, and that arbitration clause has a class action waiver, then there is no class.
Luckily, forced arbitration isn't really something that we're having to deal with
Right.
in Europe, which is very,
Right.
very nice. Just one less
Right.
hurdle to have to deal with.
One differentiation. But you never know what's going to come down the pike, and there may be other ways that you can start, looking at, can you compel jurisdiction in a different area? You never know. So those are the kinds of things, like getting creative about how can you just keep as much of the case from going forward, from the defense side at least.
Understood. Mike, I think when you were speaking earlier, you mentioned that you've often represented Americans and Europeans, potentially even in the same litigation. Can you maybe expand on that a little bit and your experiences there?
Sure. Really two observations, and they both kind of relate to the same thing. As a victim's advocate and as a lawyer who represents plaintiffs, one of the most refreshing things for me in representing EU nationals in American litigation is the benefits of U.S. litigation, the benefits of the U.S. venue with our relatively unrestricted, damages laws, and just the ability to have a case and to sue a number of defendants. When you compare that to certain EU countries where damages are relatively restricted, or you might be limited to, in a certain toxic tort claim, to a governmental benefit. For instance, we've experienced cases that had values in the home country in Europe of 5 figures, and when filed in the U.S., the same claim has the values of multiple 7 figures, or really almost unlimited. Mm-hmm. The aggravating part of that experience is that the defendants in these cases are very well aware of that and very well aware of what the law is in those other countries. And they make motions to, if you keep the case in the United States, they make motions to the trial judge that trial judge should be applying the damages models or the damages rules, or in some cases they're even like guidelines or just lists of what damages are recoverable, and that the American judge sitting in the U.S. should be applying the law of that foreign country as it pertains to damages to try and limit the recovery. So you have to be prepared for that, and you have to be ready to make the choice of law argument, perhaps have an expert ready, or at least try very hard to convince the American judge that he or she does not want to be applying the law of that particular foreign jurisdiction.
Understood. We're flying through this. We're almost to appeals, so. I think one thing that we've really realized here in Europe, especially because so many of the laws are so new, is that everything is being appealed. Interlocutory appeals, final appeals, appeals to the ECJ. That's been very prevalent because the law is so new and we're trying still to develop it. So, Glenn, I know that you've handled lots of appeals across your career, so I would love to hear just your take on kind of the lawyer's role there and some of your experiences.
Sure. Well, I'll say that, to start, that I never thought that at the beginning of my career that I would be spending so much time especially on appeals, just trying to get into court, which is something that, is I guess, the whipsaw of being in the United States, where we have a very well-developed class action jurisprudence, is that it's well-developed enough so that mandatory arbitration kind of came along when I got very active in the space. And I've spent years of my career just trying to get into the courtroom. So, the appeals in the class action space really, I was thinking about it, really boiled down to about 5 different kinds. There are discovery-related appeals. There are class action certification order appeals. There's settlement-related appeals. There's arbitration-related appeals. And then finally is the box that people like non-lawyers would think about, which are merits appeals of the actual substantive issues in the case. Regarding discovery-related appeals, that would be disputes over the contact information for the class. When I first started practicing in this area, I didn't really understand how valuable or important or why it was so important to have the contact information for the class. And I thought to myself, why are we spending so much time fighting about this? This is something that doesn't seem like it's that important. And why does the defendant care so much about it? And as it turns out, that it's so important because one of the key issues in class actions is that the plaintiff class generally doesn't know about their rights, whether it be employment or whether it be consumer. These are things that most people are generally unaware of. They may not, unless it's something very obvious where there's been like a bodily harm. If it's an economic injury or something having to do with labor and employment rights that aren't being that aren't being honored. These are things that people often don't know about. So we've litigated, often to, ultimate courts, whether, U.S. or state Supreme Courts, the issue about the availability of the class members' contact information. Also, we heard a little bit yesterday about disputes over communications with the class, and that sounds like it's an issue that's percolating in the UK. Under Federal Rule 23D, there's this issue about whether the defendant or the plaintiff's lawyers pre-certification can have communications with the class, what those communications can be about, and the court's role in making sure that these communications stay within certain areas and don't sort of end up biasing the class in one way or the other. In the second box for class certification orders, we have Rule 23F in the federal courts. In state courts, there are various kind of analogs to that. And basically, where there's a class certification order, especially where the class is certified, often that is something that's immediately appealable. And in the federal courts, one has to ask the intermediate appellate court for permission to appeal, and if it is granted, then there's an appeal on the actual merits of the certification order. There's settlement-related appeals, and these can sometimes go on for years. In the American case involving the antitrust interchange MasterCard case, there have been appeals going on for about 13 years, and these would be essentially when objectors or interveners come in and have issues with the settlement, and this can be something because they have immediate appellate rights that can hold the court, the class settlement hostage for potentially years. Arbitration-related appeals, by statute, arbitration orders are immediately appealable if they're if they go against the defendant or which is the party invoking arbitration. Those can take years, and those have to do not necessarily with an arbitration order, but the right to compel arbitration. And those are going to be the bulk of arbitration-related appeals. And then finally are merits appeals. I mean, in the class action space, we don't deal with a ton of trials, but to the extent that there's a motion for summary judgment that was granted or something else on the merits, obviously those are what we think of when we think of a normal appeal. The court found something that there was or wasn't liability, and then there's an appeal on that. We talked a little bit about, what tips there would be regarding appellate issues, and I would just have mainly three. One would be to make a strong trial court record. I would assume that in most places, just because of the nature of what an appeal is, there's this very strong push that one has to preserve issues if one wants to appeal them. In the United States, if something's not in the appellate record, it did not happen for purposes of an appeal. So making sure that issues are preserved for appeal and that the record is strong, that everything you want to be able to refer to is in there. Number two, I would say bringing in appellate counsel and bringing in appellate counsel early. In the United States, a lot of savvy defendants are bringing in appellate counsel at the trial court level to be there to make sure that certification briefing, dispositive motion briefing, and of course, if there's a trial, that appellate counsel is there to make sure that there's an eye for the inevitable appeal afterwards. Appellate lawyers also bring a fresh perspective, and I found that it's very important. Trial lawyers have been living with the case and have been living with the facts for years. They're very often dug into a particular narrative and very wedded to particular facts. We have got to argue about this. No, that didn't go right. That guy's lying. Appellate lawyers will come in and say, we need to make sure that we hew to the standards of review. We need to make sure that we're not just relitigating every single issue, but that we're actually focusing on the issues that the courts of appeal care about. And then finally, three, I would just say the tip would be to be judicious about what you appeal and how. There's a tendency for trial lawyers in all courts to want to appeal everything whenever possible. That is not often the best way to go about it for a number of reasons. One being that delay is often a killer for the plaintiff side. And it might be better in certain instances just to let something go and not to try and take a writ or try and take an interlocutory appeal, because the defendant would like nothing more than to have 2 more years of nothing happening in the case. And we want things to move forward, because if we don't move it forward, it's not moving forward. And then finally would be just the issue of not appealing things to make bad law. In the United States right now, anything that ends up in the United States Supreme Court is going to be bad for the plaintiffs. There's a 6-3 supermajority for conservatives. They are in lockstep, especially on business issues. And if we end up in front of the United States Supreme Court, it's an extremely bad place for the plaintiff side to be. We want to make sure that we don't appeal things that don't need to be appealed. And the converse of that is true in the California Supreme Court, which is very plaintiff-friendly, and defendants do not want to be there because at this point there's a 5-2 majority in favor of sort of the more liberal plaintiff side. So.
Nice, yeah. The whole know when to fold them, when not to appeal is very, very important, I agree. Well, why don't we switch a little bit to just maybe some anecdotal advice? I know you all have all been practicing lawyers and successful in different realms, so I'd love to maybe just have you all give a piece of advice or a tip of kind of a role that you have played that's really changed a litigation for the better for a case that you've been on. So it doesn't matter who goes first. If Mike, you want to hop on?
Sure. I would just say I actually agree with a comment that I heard one speaker say yesterday, that it's important to think about your experts early and to retain some of the critical experts early and start working them up. Particularly in the case that I was mentioning earlier of representing EU citizens in a transnational case, you're going to get that argument of choice of law and which law should apply to various issues in the case, particularly damages, or whether the case should even be heard in a different forum rather than the home country of the individual plaintiff. So I think it's really critical, and what I've done in cases is secure the services of a top-notch the law expert from the country where the plaintiff's coming from, and if that expert has some expertise in transnational law, that's even stronger. That can really help when you start facing those motions at the end of the case.
That's fantastic advice. Me? Katie?
I would say be creative. Don't do things the same way everyone else has done them just because everyone else has done them that way. Especially, you're in a whole new trailblazing activity right here. I have an anecdote. Can I share it?
Do it.
Time? Okay, so this is not in the class action context, but just as an example, and have fun. I guess that this is the other thing is have fun with it. But I was trying a case and I had served a jury demand, which obviously is not relevant in Europe, but the point still stands, at the beginning of the case. And the other party had not filed a jury demand. And in Colorado, if you don't file a jury demand within the first 90 days or something like that, you have waived your right to a jury. So we got all the way through the case, and we made sure to tell the judge our story early and often, right? We really wanted the judge to know what our story was, what our facts were, what our position was. We had been defrauded by another bank. We were a bank that had been defrauded by another bank. And the day before, the opposing party had refused to settle. Day before trial, we went in for our final pretrial conference and withdrew our jury demand. And that stunned the other party because they were relying on that jury trial. And so they settled that night for the full amount. So think about, the creative ways that you can use procedure and really, get yourself positioned for a strong result.
That's right. Yeah, go ahead, Glenn.
Yeah, I guess I would say, being in these cases for the long haul, is something that's been important. One anecdote that I would have is that, we'd had a case that was filed in 2007. It was on the brink of settlement when Concepcion came out in 2011. We ended up dealing with a motion to compel arbitration, and this case that was about to settle it was a relatively small class, ends up being decertified and compelled to arbitration. Rather than kind of fold them or walk away or cut our losses, we end up doing what at the time was very, very new. I had never really heard anyone do it, which was to conduct a mass arbitration. We said, okay, we have the contact information for the class because this had been a certified class, and we start talking to our clients. And a lot of folks really wanted to move the case forward. And we said, all right, we're their lawyers. We're here to make sure that they get as much as we can get for them in terms of relief. And we ended up filing these cases, and it was a huge amount of work. And we didn't really understand at the time what was involved with mass arbitration. Now our firm actually specializes and has a very well-developed mass arbitration practice. This was in the very early days of this, and didn't know about that. Fast forward to years later, a defendant that had compelled arbitration and then refused to pay the arbitration fees, multiple trips back to court in order to force them to pay it. And at the end of the day, we were able to file a large number of these cases, see them through, and ended up with settlements in the aggregate and attorney's fees that many times over dwarfed what they could have settled the case for. And this was a function of us really wanting to see the case through, of having appellate capabilities, and having the resources as a firm to actually fund this, because in the United States, we are generally funding these cases ourselves.
Fantastic. Those are all great examples. I think that's pretty much what we had programmed for you all, but we've got a little bit of extra time, so if anybody has questions for our panel, we would be more than happy to entertain them. Otherwise, you'll get an extra 5 minutes to have some more coffee. Yes, sir. Yeah, hang on just a second.
I just wanted to ask about cooperation between members of the plaintiff bar, or even the defense bar, about common interest subjects such as law or, an appeal, help in relation to an appeal. In the UK, we've just started an organisation, CALLA, Collective Redress Lawyers Association, which is intended to lobby about the law. And I think the Dutch are also thinking about it. And I just wonder whether that's happened in the States, what your experience is.
Yeah, I'll weigh in on that. That's a great question. Collaboration on the plaintiff's bar is a huge part of our practice. We're active in a number of those kinds of organizations in California and nationally. The Consumer Attorneys of California, the National Consumer Attorneys Association, the California Employment Law Association. We get together to do amicus work for each other on appeal, to make sure that important issues are getting the support of friend of the court briefs, which is essentially non-parties who will let the court know some additional information about important issues to push the law in the right way. We'll, behind the scenes, collaborate, call each other, share briefs with each other, come in, talk even about our experiences, within the bounds of what we're allowed to talk about regarding, particular defendants and causes of action that are now moving in the right direction. We make sure we don't file on top of each other, and when there is, we make sure we can coordinate and come together and to make some sort of a deal so that we're not stepping on each other's toes. And then often we're co-counseling, and co-counseling relationships are often born in those kinds of organizations. So for us, it's just a huge part of our practice.
Yeah, I would just add to that in the mass tort setting. I'd mentioned a networked mass action, which is very common in toxic torts in America, and there are cases where the plaintiffs share information, the defendants share information. There might be a plaintiff steering committee, and there can be databases of shared information about medical causation and different facts and shared depositions. So it's quite common and very advantageous in a mass action where you can't get class action status.
We have this saying in the U.S. that a rising tide lifts all ships, and I think that's one thing that I'm really excited that the European kind of collaboration has really started, because it has really, really been beneficial for I'm sure all of us, and our practice is growing there. But if I do better in a case, then it's only going to help the next case down, and vice versa. So we're super excited about Corla, and I'm really excited about the Dutch getting involved in that as well. So I think there's plenty of opportunity to go around, and collaboration is going to be absolutely key to get anything pushed forward here. I think I saw another hand a little further back. Is it still, you still want it up? No? Anybody else? All right. Well, thank you all so much. Thanks to the panel. Have a great rest of the time here and enjoy Amsterdam and the rest of the conference.